Can you please look up this site?
See if we can figure out something.
Well, I've got 3 people in the waiting room already. Open the. Well, I've got 3 people in the waiting room already. It says July 1 at 1:15. Yeah, Friday, July 1st. That's what the summons says. I just noticed that. Oh, heck. Let's see who's here. Good afternoon, Mr. Flowers. Can you hear me?
Yes, Your Honor.
Oh, great. Ms. Caldwell, can you hear me? Good afternoon, Mr. Kreitz.
Good afternoon, Your Honor.
Mr. Bush is here at the court with me. Mr. Bush, why don't you come up and have a seat?
Hello, John.
Ms. Caldwell, would you join us, please?
Here.
Very good.
Hello.
Hello. All right, we've got 2 of you here for landlord-tenant proceedings. We're a little early, but I'm going to go ahead and advise you of your rights as tenants in landlord-tenant proceedings. As a defendant in a landlord-tenant proceeding, you have certain rights. Mr. Flowers, in your case, it's a demand for non-payment of rent. And Ms. Caldwell, in your case, it's a termination of tenancy where they simply want you to move. In either kind of case, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. I expect that she'll be joining us shortly. You have a right to have the matter heard here in St. Joseph County, where the property is. Excuse me a moment. You have a right to trial by a judge or by a jury. You have the right to demand a jury trial, and if you do that, you have to do it at this first initial hearing or make the filing in writing within 5 days and pay the $50 jury demand fee. We'll provide you with that form if you need it. If you're unable to afford the fee, you can ask the judge for a waiver of the fee. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be eligible to get assistance from the Michigan Department of Health and Human Services, a coordinated entry agency. In our county, that's Community Action Agency. A housing assessment and resource agency. In our county, that's Neighborhood Inc. And they are out of funds till the next fiscal year, and I'm not sure when that is. Or if you're a veteran, you may be eligible for veterans assistance under a federal veterans program. And you should have received that with the packet that you got. We included that. You do not need a judgment against you to receive the help from the places listed above. A copy of the summons and complaint from your case are sufficient. If both parties are interested in trying to reach a mediated settlement, the court can refer the matter for mediation and help set that up. You may be able to reach an agreement with the landlord that means the case would get dismissed, in which case the court would find or would accept a conditional order of dismissal. We would either provide you with that form or show you where to get it, where to find it, if the attorneys are not involved to do it. Our first case is set for 3 minutes from now, and we got to let the clock tick a little bit. And Mr. Flowers, you're at 1:25, and Ms. Caldwell, you're at 1:30. We won't need to wait. If the parties are here, we'll just go when everybody's here. Joining us on the feed is Attorney Meg Bauer from Legal Aid in Kalamazoo.
Good afternoon, Judge.
Good afternoon. Elaine, there's a problem with this first notice for Mr. Pelfrey. The summons says Friday, July 1st, and today is July 1st, but it's not a Friday. I hope that doesn't come back to haunt us. We won't even be here on Friday. This is file number 24781LT. It's entitled Kreitz Rentals, Inc. versus Roy Pelfrey and any other occupants. Now, this is a property at 127 North Nottawa, one of the apartments there. Mr. Kreitz, did you inherit this tenant when you bought this?
No, Your Honor. Roy has been with me quite a while. It's South Nottawa, by the way.
All right. Yeah, that's an S. Sorry about that. Thanks. Well, there is no lease, despite he's been there for a while. If there is a lease, I don't have a copy of it. The plaintiff has moved to terminate the tenancy. The matter was noticed clearly on the notice. It doesn't say Friday. It just says July 1st. The summons had Friday on it, but the notice for today's hearing clearly is for today. Notice to quit was served way back in March. As far as you know, Mr. Kreitz, is he still there?
I believe he still is, but it's mainly his son and all his, I'll call them friends.
Is his son on the lease?
No, Your Honor.
What's his name?
I don't know the son's name. The renter's name is Roy.
I have reason to believe his name is Willard.
Right. Have you been contacted on this, Ms. Bauer?
No, and we would be conflicted out.
Okay. Well, no one is here. Roy, Willard, or any of the son's friends. The notice is clearly for today. He was personally served by Sergeant Morse. And he is subject to default. John, I don't think I have a judgment here.
Well, we can remedy that very quickly this afternoon.
Sure, I'm not. No, I don't have one. The page from today is July 11th. Do you have one with you?
No, I don't see one in my packet. Well,
All right, John will provide. A judgment. His problem with a notice. If he shows up Friday, he isn't going to find anybody here. So we'll see if he does. We'll have to address it. But the notice clearly says July 1st at 1:15. So Mr. Bush, I'll await your judgment and I'll sign it effective this date.
thank you, Judge. Thank you, Jamie.
Thank you, Your Honor.
Thank you. Our next matter is Lamp and Key Realty versus Robert Flowers. Mr. Howard Bush is joining us. Diana Lamont, the manager for Lamp and Key, is here. And Mr. Robert Flowers is here. This is file 241064. Ms. Lamont forwarded to the court a spreadsheet of current arrearage. As soon as Mr. Bush joins us, I did go through the rights while we were waiting with Mr. Flowers and Ms. Caldwell. Howard's going to have to get Valerie to help him again to turn everything on. While we're waiting, Ms. Lamont and Mr. Flowers, the spreadsheet you sent last week shows that the current arrearage is $4,375. Is that through June?
July.
That includes July? All right. And the court costs are 75, 56, and 68. $189 makes the total arrearage 4,574.15.
That is correct.
All right, Mr. Bush has joined us. Mr. Flowers, what's your position here?
Tomorrow I meet with Stoney to see what I can do as far as VA help. And my lease is up also this month as well, so we've been actually trying to find a different place as well. I have nothing against Lamp and Key Properties. They've been great to me. They've worked with me as much as they could. Sadly, we're here.
Well, we've been through this before and they did help. The law requires, as you know, that I adjourn this at least 7 days,
Yes, Ron.
which would take us to next Monday, July the 8th, which is full, but we'll fit it in. How about 2:15? When Monday, July 8th, does that work for you, Howard?
Yes, it does. I can be
Is
here.
that enough time in light of the 4th of July holiday?
Are you speaking to me, Your Honor?
Yes.
I believe so. I'm taking a half day off of work to meet with Stoney in the afternoon before the holiday to see what we can get done.
All right, very good. Do you have any questions?
No, Your Honor. They
All right.
didn't say that, so I can't complain.
All right, well, all right, you can get back to work. I will see you on Monday next, and we'll see where we are. Hopefully you can get some assistance, maybe find a new place.
Yes, Your
All
Honor.
right, you're good to go. Thank you.
All right,
Will
thank
there be
you.
another month's rent due on Monday?
Well,
Diane?
according to Diana, this included July's rent.
That's what I thought.
Okay, so we're good through July.
Yeah.
Yes.
All right, very good. We'll see you all next week.
All right, thank you, Your
Right.
Honor.
I think I have the next one also.
Yes, you do. I advised Tina Caldwell of her rights. She was here early and we went through it, so we're
Edgar
cruising
Miller
right
is in
along.
the office.
This is entitled Edgar Miller versus Tina Caldwell. The file number is 241067 LT. Mr. Howard Bush is here on behalf of the plaintiff. Edgar Miller has moved to terminate this tenancy. The complaint was filed in June and the notice to quit was filed on April 6th. So Ms. Caldwell, your landlord wants you to move. And what's your position?
Right now I'm waiting to talk to legal aid. I have an appointment, a first appointment in about a week and a half. I'm having a hard time getting subsidized apartment. Everything's full. I'm
Yes.
disabled. I'm disabled and my machine is hooked to my house that I'm in. I have a room that is my hospital room. And I have nowhere to put my dialysis equipment if I go homeless. I don't know. I'm in a bind. I don't know. I understand I'm being evicted.
All right, well, you got,
Your Honor, please, I would note that we were simply terminating the tenancy.
yes.
We have not asked for back rent. There is a huge arrearage in rent on this. We're simply asking that she be removed from the premises.
When was rent last paid, Mr. Bush? Do you know?
When was rent last paid, Edgar?
At least a year and a half ago.
At least a year and a half ago. There's been no rent for a year and a half.
No, that's not true.
Well, they're not asking for back rent, but when do you say rent was last paid, Ms. Caldwell?
October. In October, I offered him a third of my income and a third of my check from there forward until I was able to find a place. And he told me that was not enough money.
Well, that's his right. And in fact, what this process is about is to compel people to move who wouldn't otherwise move. Right now, you haven't paid any rent for months and months and months. He says a year and a half, you say 10 months. So he's subsidizing you. Who's paying the utilities?
I am. I pay everything from trash to electric to gas.
That is correct.
Well, that's something. The
I
reason
think my-
people don't move is because they can't find anywhere to move to.
That's my problem.
Well, there's not enough housing, period. And there certainly isn't enough subsidized housing. But by the same token, the landlord doesn't just have to leave somebody there indefinitely because they can't find any place to move to. We've had a number of cases where the landlord wanted to sell the house. They wanted to get it empty so they could refurbish it. They wanted to allow their kids to move into it, where they were just terminating it just because the lease was up and they wanted to terminate it. You may have some sort of a defense because of your medical issues, but we can't wait a month, a week and a half for you to have your appointment with legal aid. Meg Bauer is here with legal aid right now. We're going to continue this matter to next Monday.
Okay, my appointment with the legal aid is July 9th.
All right, well, let's talk about that. Meg, can you accelerate that?
So when I was doing our conflict checks, I did see Ms. Caldwell's intake and that she has an appointment scheduled with our intake attorney on July 9th. I will communicate with the support staff that scheduled that. I'm not sure why they scheduled it that way,
All right,
and
well,
see if we can't get it
let's see
moved
if we have
up.
another option. Howard, we have a short week this week. We only have 3 working days. If we
Oh,
didn't
that's
go
fine.
to July 8th, we could go to July 12th, which would be next Friday, which would be 11 days from today.
We've got to set it for another hearing with July 12 next Friday. Be agreeable?
I don't know what's gonna happen then.
You'll enter a judgment, I assume. That, I believe July 12th,
All right.
I assume in the afternoon or.
Yes, July 12th at 1:50.
1:50?
Yes.
That's satisfactory.
Now, Ms. Caldwell,
Yes.
if they get what they ask for, you would have until July 22nd to move out, or you would be subject to being evicted. If there is some defense or some emergency medical defense or something that I'm not aware of that legal aid would do, I would probably start to order that you pay rent into escrow. How much is the monthly rent, Howard?
600.
600 a month.
All right, we'll cross that bridge when we get to it. But for now, Ms. Bauer, I guess you can leave her appointment for July 9th.
Oh, thank you, Judge.
And we'll have the hearing on Friday the 12th. Friday morning, Howard, is just crammed full of attorney pretrials.
I have a
we'll make that
pretrial in and I have a dentist appointment, so I'm juggling.
All right, well, we'll hope for the best. Anyway, Ms. Caldwell, you're in a tough spot.
I know.
He's wanted you to move since early April 1st, and probably before that. Mr. Bush wrote you a letter back in March. And so people wouldn't move unless I ordered them to move, and the sheriff came and moved their stuff. Have you talked to DHS or anyone else to get any emergency help?
Yes, I'm in contact with my caseworker with DHS. She's gonna try to help me with some relocation money,
Okay,
help me relocate, but I have to find a place to relocate to. That's where my holdup is.
they don't have a lot of money left for emergency rent. They have different pools of money. One of them is relocation.
Yes,
Yes, $600 is low on the low end of the scale, particularly for a house.
I only get $900 a month on my disability.
Yeah, you certainly need a subsidized place.
Yes, sir. I've got applications in everywhere.
I hear this story almost every week, and
Sure.
I don't have a good answer to it. It's a solution without a real good problem without a real good solution. Anyway, we'll address this further next Friday at 1:50 by Zoom once again. We'll see if legal aid is going to appear on your behalf or file some sort of response. But if they do, I'm going to order that you pay $600 for July's rent and $600 for August rent. And we won't even get to first base if you're not able to pay the rent. So you're in a tough spot. All right, do you have any questions?
No, sir. I understand.
All right, I'll see you next Friday. You're good to go.
Okay, thank you.
We will be there.
All right, I'll be here.
Thank you.
Now, our next matter is 135.
Thank you, Judge. I recognize the court had no reason or obligation to do that. So,
Well, it is a short week. Probably no one at legal aid is going to wants to work Friday either. So she's in a tough spot.
don't disagree with that. And I think that's exactly what happened. Our intake attorney is out part of this week, most of this week.
Now, I don't understand this next case. It says they were unable to serve them, but it's a residential landlord tenant case. They'd serve it by posting. Here's some additional correspondence in here. We received a fax dismissal by the plaintiff, which I don't have. Maybe it means they've moved off a lot. But this next case, Washburn Lake Village Mobile Home Community versus Cassandra Strasser and Russell Steven Strasser is dismissed. Elaine, could you print that dismissal for me? I didn't catch it. Maybe they couldn't serve it because they moved the mobile home off the lot. That might explain why we don't have it. Right. Our next matter is at 2 and then 2:10. So Meg, I'll put you in the waiting room, let you work on your other stuff. I've got a couple general civil cases that'll be up in a couple minutes, so I'll bring you back in when we get ready to do the other stuff. We do have a motion to set aside an installment payment order. That is set at 145. And it put an answer on a piece of paper of an odd size. It's bigger than 8.5 by 11. So it doesn't fit with the other stuff very well. So, oh, I already did sign it.
I think I did cases before.
Okay. Okay, have those. John's. All right, let me sign that too. That summons says Friday. Did you see that?
Yes, I did.
Well, hopefully that won't be a problem. July 11th is the date. All right, you can have all these files so far.
Okay.
Thank you.
Thank you.
Good afternoon. Are you Jasmine Mitchell? All right, I have to ask you to unmute your mic.
Can you hear me now?
Yes, I can. Thank you.
Yes, thank you. Sorry.
You're fine. That happens a lot. All right, this is set for about 2 minutes from now. We're waiting for the attorney to log in and then we'll address it.
Okay, sounds good.
Good afternoon, Mr. Hintz.
Good afternoon, Your Honor.
I'm here with Jasmine Mitchell, and I'm going to go ahead and call this case. I appreciate everybody being here in a timely manner. This is Glen Oaks Community College versus Jasmine Mitchell. The file number is 22178 GC. Jasmine Mitchell is here by Zoom, and attorney John Hintz is here on behalf of the college. I was just at the college last week. They had a very nice retirement ceremony for their current president. Way back in 2023, in February, a consent judgment was entered with the damages in the amount of $2,611.63, and adding court costs, it was $2,803.75, with the provision that the defendant shall make payments of $100 per month starting February 4th of 2023. Apparently, in February of 2024, the defendant stopped making the payments, and the plaintiff filed an order to set aside the installment payment order and allow them to pursue garnishment. Ms. Mitchell wrote a letter on a weird sized paper. It's like artist paper or something, but anyway, I was able to read it all. Indicating that you lost your job, you're hoping to get a new job and get back on track. And that's really where we are. Mr. Hintz, I've been setting these, especially with the advent of Zoom, so you don't have to drive out here or send somebody here, just for a hearing to get everybody in the same place at the same time. So, Ms. Mitchell, am I correct? You lost your job, you were hoping to get called back to work, and you want to get back on track on the payments. Is that true?
Yes, sir. And actually, I just went to a job interview this morning, a job that I've been waiting for a few months to get a call back on. Say it was just the interview process, but I believe it went very well. And I'm actually very hopeful that in the morning I will have a call back from the HR woman to proceed with a background check and whatnot.
And where is that?
At Utilimaster in Bristol, Indiana.
Mr. Hintz, what's your position?
Your Honor, when we started this installment order, Ms. Mitchell had made some payments. As she's explained, and we have no reason to doubt her, the last payment we received was in December of 2023. And she had been making payments to kind of catch up missed months of $200 a month payments. But we haven't received anything since December. Now, I understand that she's out of work and has some financial issues. And if she's not employed, then technically there's nothing to garnish at this point. But if something were to change, then of course we would like to have the ability to do that. If Ms. Mitchell would like to catch up the payments, the current balance, Your Honor, when I filed my motion back in May, was approximately $1,746.23. It might be a few dollars more since when I signed the motion in the middle of May. But with that, there have been some missed payments, no payments yet in 2024. And we are in July now of 2024. So we'd either like to have some type of a plan that can catch up those payments quickly, or we'd like to have the installment order set aside as it's not doing anything for anyone at this point. Thank you, Your Honor.
All right. Well, that is a reasonable response. You're hopeful for a job. The economy there were jobs all over the place, and then there weren't. A lot of the mobile home factories are laying off right now. They're slowing down. I'm talking to people every day that are on layoff or 3 days a week or that sort of thing. There are people hiring, to be sure. So they're looking either for a plan to get caught up, like $200 a month, or allow them to do a garnishment. If they do a garnishment and you do get a job at Utilimaster, you're not gonna like it because it's gonna take a big chunk of your check. Could you do some sort of plan where you pay $200 a month going forward, say starting August 1st?
Yes, I mean, if I start tomorrow next week, and I will be in contact to, as far as like, did I or did I not get the job? But I'd prefer obviously not the garnishment, but $200 is very reasonable, and I could absolutely do that because I did mean when I wrote that letter, I meant that with all my intentions that I do want to get caught up. All of these things affect my credit score. It's been a rough year, and I have a lot to make up for, but $200 is reasonable, very reasonable.
All right, I'm gonna deny the motion to set aside installment payments. Defendant agrees to pay $200 per month starting August 1st. In which case, it would certainly make up for the past months, and at $1,700, it'd take about 9 months to pay this off. I'm sure you'd like to get this off your back so
I
you
do.
can concentrate on other things.
Yes, sir.
All right,
Miss-
let's recap. I have denied the motion to set aside installment payments, so they will not be able to garnish your wages. They could still garnish your tax refund, although generally they don't. And as he mentioned, interest is accruing on this. So when it lays dormant like this, the bill goes up. But if you can start paying $200 per month starting August 1st, that will help pay this debt, and you won't be subject to garnishment. Anybody threaten you or promise you anything other than what I said here to get you to agree to that?
No, sir.
No, Your Honor.
All right, Mr. Hintz, very good. All right, thank you both for being here.
Thank you, Your Honor.
And
Thank you, Mr.
I've
Mitchell.
signed that order.
Thank
So
you. Thank
hopefully
you
you
both.
get the job and get back on track. All right, you're good to go. Thank you both for being here on time.
Thank you, Your Honor. Thank you.
Thank you.
All right. Next. Matter is set for July 1st.
The judge.
Good afternoon. That's the first time I've ever seen you have anybody in your executive suite there at your house.
Well, actually, I almost had to go upstairs in my office because we have construction workers around. We have no pictures on the outside walls, but they said they were kind enough to shift the other end of the house so you won't hear the bang, 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 bang.
Okay. We gotta let the clock tick a little bit.
Yep.
This matter is set for 2. I got 153. Meg Bauer from Legal Aid is in the background. I'll bring her in.
So are you gonna be a video technician in your next life?
Boy, I'm not very good at it. And I'm not sure how much time I've got till my next life, but hopefully not. I am doing, here she is. She spells her name Taylir. And
Yeah, I put in the documents I submitted this morning, AKA TAYLIR.
Okay, there you go. Oh, and the door when she comes in, they hear shuts, right? Oh, yeah. Oh, okay. I can just wait.
All right, Miss Bishop, can you hear me?
She's not here yet.
All right, sorry. Could I ask you to take your gum out?
Oh, yes. I'm not a part of it. I'm just her mom.
Okay, yeah, you were here on some of the other matters. Thank you.
Yep. Waiting on you. Go.
Good afternoon. I'm going to call the case. This is entitled Robert Morris versus Taylor Bishop. And Miss Bishop spells her name Tiylir. And I'm familiar with her. Are you Taylor Bishop?
Yes, sir.
Also present is Attorney Robert Brothers on behalf of the plaintiffs, and also with us on the screen is Meg Bauer from Legal Aid. This is filed as a termination of tenancy for emergency damage to hazard to property. Miss Bishop was in jail and had some issues that we were trying to address. She also has a trespass criminal charge pending an attorney pretrial on July 12th. And I believe the trespass is at this premise, which is 104 North Kalamazoo Street. And make sure, is that correct, Miss Taylor, Miss Bishop?
No, sir. The trespass.
Oh, this is the trespass at the Shell station, right?
Yes, sir.
Okay, all right, then it doesn't affect this. They attached pictures and the house looked like it was a nice house, but it is in very poor condition. Are you even still there?
Sir, I have not been back there, for like about a week, maybe 2 weeks. Since the 31st. But I still currently reside there. I had broken some windows out, but that was the only damage that had been done to the house. But I was planning to repair those windows, but put plexiglass in some of the windows that were broken out.
Well, the inside of the house looks like,
Also, sir, I'm sorry to interrupt. Robert Morris had given me verbal confirmation that I could do whatever I wanted to that house. So I'm also going to state that right there as well.
he gave you verbal permission to trash the inside of his house?
He said that I could do whatever I wanted to the house. That's what he said verbally. I promise.
Well, now he wants you to move.
I want to clean that
Sooner.
house up, honestly, and get him back there.
Mr. Brothers, what's your position?
My position, Your Honor, is that Mr. Morris is in hospice. There's a question on his capacity to legally contract, and that's why I submitted the power of attorney. He has appointed his mother, Judy Morris, as his attorney in fact, and also the under a remainder owner of the property under a Lady Bird deed. So I guess we would, number one, dispute that he indicated that. Number two, he did indicate that he didn't mean to destroy the house. And number three, that there also are the remainder people, both Mr. and Mrs. Morris, of the plaintiff's mother and father, are remaindermen on the property. And it's clear that my understanding is the defendant has given a story about there was remodeling going on, and we think that's just an excuse. But long story short, Citation's been issued and we need to bring the property back into compliance. And that's why we're pursuing this matter under this provision of the statute to evict the or terminate, I guess, for lack of a better term, any rights that Ms. Bishop has in the property, so we can undertake to rehabilitate the property and comply with the appropriate ordinances.
You indicated that a citation has been entered. That's the Village of White Pigeon has cited the owner because of the condition of the property. Is that correct?
That's true, Your Honor. And I can give you the citation number if you would like.
I think I could look it up, but yeah, go ahead.
It's a WP 2405001. And it should be in the court filing at the back of the amended complaint exhibit.
Yeah, I believe it is.
Sir,
All right.
Sir,
Now, just a minute. Miss Bishop, you say you haven't been there in 2 weeks?
yes, sir. Let me speak for myself, please.
All right, go ahead.
Sir, when I had first moved in there with Robert Morris, that place was completely disgusting trash, and I literally, I've kept that place nice and cleaned up. This was a spur of the moment type of decision on the windows and stuff like that, but literally I could have that cleaned up in 2 days if I went back there. Not even 2 days. I've raised the property value of this place by $20,000. I saw that on paper for myself because I was overseeing a lot of Robert's care while he was there. And so I was like helping caretake for him, not legally on paper, but that's what I was doing. Plus I brought the property value up like $20,000 just by keeping that place maintained and kept up. When I first moved there, that place was disgusting trash. Robert did need help and I did help him. And I'm sure that he wouldn't mind if I was there with him again. It's just, I understand why his family is taking over for some stuff in this instance, but I just want you to know, I normally keep that place very well kept and maintained. I just had a bad judgment call and made some poor decisions that I learned from, but I, in full honesty, would want that place cleaned up and maintained so I can keep up to the city ordinance and everything like that.
Well, that ain't gonna happen. They don't want you to come back in and clean it up. They want you to just move out. And they want you to move out today. They filed this as an emergency, damage to health or hazard to property. So the family doesn't want to establish a tenancy with you. There's no lease. How long did you live there with Robert?
Yeah, since 2022 sometime. I'm pretty sure maybe even 2021, the end of the year, 2021.
I had looked at some of your stuff last week where you listed your address.
Yes, sir.
And in 2013, you listed your address at 104 North Kalamazoo Street.
2013?
Yes, unless they changed the stuff 2006. Let's see here. 2016. Unless the computer now automatically changes the address.
Yeah, no,
everything.
Sorry.
Maybe it does that. Anyway, when did you move out?
I haven't moved out. I haven't been there since about the 31st, but I haven't moved out.
31st of what?
May.
Mr. Brothers, what's your position?
Well, my position is, Your Honor, that she just indicated she could have it rehabilitated within a matter of days. But I would point out to the court, it's been a month since the citation is issued and there's been no effort to do so. So I would suggest that's a hollow promise.
Sir?
Yes.
If I may
Just
say
a minute.
something? Okay.
Yes. Well, she was in jail for some of that time and unable to do it. She also had a mental health commitment in there someplace. She was struggling with some other issues. She's much better the last 2 times I've seen her than she was at the front end of this. She was having some sort of a episode, but can you accept, Mr. Brothers, on behalf of your clients, if she vacates within 10 days?
We would prefer not, but in order to get this resolved, I would assume that that's okay. Is that okay with you, Jim?
Well, I had somebody to come in and clean on the 8th.
Could we make it 7 days, Your Honor, because we have a scheduled appointment for somebody to come in and clean up on the 8th.
All right, Ms. Bishop, can you remove your property within 7 days?
Yes, sir.
All right. At this point, don't worry. I mean, it looks like.
Sir, may I ask something?
Certain.
Okay, if it's all right with Judy Morris, if when I'm vacating stuff, if I could put some things in the garage, if it surpasses that 7 days, and just put some stuff in the garage, because right now I have a vehicle in the garage that I do not have a key to, and I'm gonna have to find some way to get that code out of there, and I don't know if I can do that within 7 days. But if I just move my things out to the garage in order to get everything moved, if that would be acceptable for her. The garage is pretty much cleaned out and empty already because I kept that place very nice.
Mr. Brothers, what's your position regarding that?
That would be a case of the camel's nose still remaining in the tent, Your Honor, and my client is not.
I think at the other end, camel's rear end is still in the tent. Thought I had a judgment here, Bob, but I don't see it.
I sent one over this morning, Your Honor.
Elaine, could you give me the judgment in this case? You're gonna have to get your stuff out of there to the best of your ability. Otherwise, they'll have the ability to do it. Now, when you move, you're supposed to give your forwarding address in writing and turn in the keys within 4 days of your moving. I can't tell what happened here, but whatever it was, it wasn't good.
Right.
And anyway, defendant has 7 days to remove property from the premises. So let's talk about that. Today is July 1st. That would give you until July 8th. This special statute for emergency damages allows an immediate eviction. As a general rule, we have to set a second hearing 7 days away, and then there would be 10 days after that day. So we've shortened this by 10 days.
Does that mean that in that time before we meet in court again, does that mean during that time I could be moving my things?
We're not going to meet in court again. You're going to have all your stuff out by next Monday.
Oh, okay.
Where are you staying? Don't have to tell me the street, but you're staying with your parents?
Yes, sir.
All right, I think that's what you told me in the other case. I'm gonna see you next Friday on July 12th on that trespass case.
Yes,
And maybe we can resolve that too. I'm waiting for the clerk to bring me the order so I can sign it while you're still here. And I'm gonna set the appeal date as the same date. Here it comes.
It was a blank judgment.
Oh, well, we'll put stuff on it. It's just the form, didn't have anything in it.
I can send another one that's partially completed. I thought that's what,
Well, she's here and I'd like to give this to her while she's here.
okay.
So I'll show a consent. The date for the eviction is July the 8th. That means you'd have to be out by that day or you'll be evicted on the 9th. Not ordering any money damages. If they're gonna sue you for money, they could do it in a separate action. But at this point, they just want possession of these premises back.
Okay,
Yeah.
sir. Great.
May I ask, because the house is boarded up, that we request the defendant to schedule the time for her to be admitted so that we can make sure the boards are removed without further destruction of the premises?
All right.
We moved her.
You know how to get a hold of the parties?
Sir, I didn't even put boards up on the house. I'm not sure who did, but I did not put boards up on the house, so I don't know why I would have to remove boards from the house.
Well, you don't have to remove them. They want to remove them so you can come get your stuff out.
Oh, well, okay. I already have keys though.
The keys don't work because the house is boarded up.
There's another way to get in the house though.
You need to get Judy those keys back.
Well, just contact them. Do you know how to contact Judy to do this?
Yes, I do.
All right. All right, I'm gonna send this out. Now, I wasn't afraid to have you in the courtroom. I put you in that conference room in case I needed to set a consultation with Meg Bauer from Legal Aid or with you and the parties. But Meg, you don't have the benefit of being able to see the photographs with the pleadings, but this was a cute little house that got in dire shape. So if you go out to the counter, Miss Bishop, we'll put the heading on here. You have until July 8th to vacate as opposed to immediately today, which is not even feasible, but it's a give and take on each part. So they'll contact them, they'll open the premises up so you can get your stuff out. And then they can take the house back and try to remediate this. All right, you're good to go.
Thank
All
you.
right.
Do you have any questions?
No, sir.
Okay, all right, very good. Mr.
Thank you.
Brothers, I'll see you next time. Thank you.
Thank you, Your Honor.
Have a good day.
All right, thank you. Mr. Porter, which case are you on? I don't have a case for you.
Good afternoon, Judge. As you know, I represent Florence Township. We have a
Okay,
read, so I'm just listening in to see
okay,
what
very
the.
good.
Thank you.
Tricia Reed is here, Casey Reed is here. This is file 24727 LT. It's entitled Casey Reed versus Tricia Reed. And this is a property at 63976 Bergner Road. Also present is Mr. Jacob Porter, who is intimately familiar with this property. And he was representing Florence Township, as he said. And he's aware of the background of this. Anyway, we had a hearing on June 24th, and we continued the matter until today, which was actually 10 days. No, it was 7 days. We continued the matter until this morning. Miss Casey Reed is now the owner of this property. Her stepmother, Tricia Reed, is the occupant. She is intending to have this place vacated. And she indicated last week she intends to turn it over to the township. The property was in very poor condition when I went out to inspect it. It's probably got groundwater issues and I don't know what else. Miss Casey Reed, are you still wishing to have this property vacated?
Yes, I am.
Tricia, what's your position?
I'm fine. I have a place to go. I just can't move until the 15th.
Well, the law gives you 10 days from today, which would be the 11th. Casey, are you willing to allow her 4 more days to move by July 15th?
I would prefer that I would only have to give her the minimum legal, the legal amount that I have to.
All right, well, that's up to you. I will tell you this, it's a lot of hassle to go through an eviction. Let me say this, you will be able to evict her on the 11th, but you don't have to. It'll be a lot easier if she moved her stuff out of there and if you had the sheriff come do it. But I find that she has 10 days from today. I'll repeat that. 10 days from today is July 11th. Miss Tricia Reed, there's no money judgment issued here. You have until July 11th to appeal this.
Okay.
Casey Reed, you have the right to ask for an eviction after July 11th. That means the sheriff would come out and put her stuff out. But if she's in the process of moving, it might be easier to just wait till she gets out, but I'll leave that up to you.
Okay.
Now theoretically, Tricia Reed, when you do vacate, you're supposed to turn in your keys and give your forwarding address within 4 days of your moving.
Okay.
Mr. Porter, does the township have a plan for this? You're on mute.
Sorry, just saw a pop up. As far as what the township's planning on doing with the property,
Yes.
I'm not aware of any plan at the moment, but as soon as the
I thought they
eviction,
may well raise it and just make it a flat piece of ground, but that's up to them, I guess, if she does sign it over. All right, Casey Reed, do you have any questions?
Yes, Trish changed the locks on the house, and
I'm
there's
taking my locks with me when I go.
okay, then no other questions.
All right.
Well, actually, she does have animals, and I want to know if they're going to be out too.
Absolutely.
Yes.
Okay.
Tricia
Yes, sir.
Reed, do you have any questions?
Nope, that's good. So I have till the 11th at midnight. Is that how that works?
Yes.
Okay, perfect.
All right, thank you.
Thank you.
All right. Okay, that brings closure to that case.
Thank you,
Closure to it. All right, thank you, Mr. Porter. Thank you, Casey. Thank you, Kelly.
Judge, I'll get out of your hair too.
All right, thank you, Meg. All right, that finishes our landlord tenant docket. It's 2:18. We have a small claims docket that begins at 3 o'clock. So we'll take a short recess. And be back. All right, we're on the home stretch here. We've got 3 small claims matters. And then get ready for tomorrow. Good afternoon.
Hello.
Mr. Mostrom, can you hear me?
Sure can. Yep.
Ms. Stalzer, can you hear me?
Yes, I can.
We have 3 cases scheduled for this afternoon. 2 involve Grand Rental Station. We're going to do those first. They may be defaults. We'll see. Right now, just Grand Rental is here. If you're here from Grand Rental, would you join us, please? I can't see you or hear you.
I'm trying to get the video to work.
Hello, Court Security. I'm about to start small claims. Do I have any customers out there? All right, thank you. Bye.
I'm not sure why the video is not working.
I don't know. You did this okay last week.
I was on a different computer. Give me 1 second.
She's gonna start over. I used to be able to turn people's microphones and cameras off from my end, but they took that feature away.
No, it's not on. Is that better?
Yes.
There it is.
All right, it's 2:59. In 1 minute, we'll start our cases. We're gonna do the 2 grand rental cases first, and then we will address our other matter. All right, it's 3 o'clock. Clock on the wall says 3 o'clock. There are 2 grand rental cases, and we're gonna call those. Are you here on behalf of Grand Rental Station?
Yes, I am.
And would you state your name, please?
Amber Letson.
Amber, I didn't get your last name again. I had the same problem last time.
Letson, Letson.
All right. And what's your position at Grand Rental?
Assistant, like in the office.
All right, would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, Your Honor.
All right, let's start with the first case, which is Grand Rental versus Lakeisha Hawthorne. This is a claim for $409.88. Again, the defendant rented merchandise and failed to turn it in a timely manner. Is that correct?
Yes.
And that $408 is additional rental fee?
Yes, it is, Your Honor.
Anything been paid on this?
No, we received a letter in the mail from the defendant's answer that she agreed I will pay the plaintiff the amount on the claim. And
Yeah,
then-
she said she'd pay within 30 days.
Yes, and we
So-
haven't heard from her.
All right, I'm gonna show this as a consent. Defendant agrees to pay by August 1st. See judgment. All right, the next matter is Grand Rental Station versus Matthew Killian. This is a claim for $455.30. Again, for property rented and not returned in a timely manner.
Yep, and for fuel cost and damage to replace the teeth on the
It was a stump grinder, wasn't it?
yes.
All right, well, he's not here to argue about it.
Nope, and when it was returned, he didn't return it. Some other gentleman returned it for him. And his name was Anthony.
Miller, but the guy that actually rented it was Matthew Killian.
Yep, correct.
I find by default the defendant is responsible. The more you do of this, the better you'll get. Like I said, this part is easy,
Yes.
actually collecting the money, although if Ms. Hawthorne pays, that was fairly effortless. All right, that didn't take very long, 4 minutes. You have two judgments. One, hopefully she'll pay as she says. The other, you can start collection after 21 days.
Okay,
Do
thank
you have
you.
any questions?
No, thank you.
All right, I'll see you next time. All right, our next matter and our final matter of the day is Meebs. Is that how you say it?
Oh, yeah, it's just an abbreviation, but yep, that works.
Meebs LLC versus Cecilia Stalzer. Meebs is by Michael Mostrom. Would both of you please raise your right hand? You both swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes.
Yes, Your Honor.
This is a claim for $1,000. Let me get these other two out of here. Depends on who you ask. Mr. Mostrom claims that it is an advance on work that was to be reimbursed by services to the company.
Correct.
Ms. Stalzer states we were in a relationship and this was a gift. There is a bunch of text messages which are very hard to discern. They're hard to read the way they were scanned in, and it's hard to tell who was talking to who. At any rate, there's more going on here than a claim for $1,000. This is a relationship that has come to an end. If I understand correctly, Ms. Stalzer, you have a personal protection order against Mr. Mostrom?
Correct, Your Honor.
And what county is that from?
That'd be Ingham County.
Eaton County?
Ingham County.
Ingham, okay. So we've ended up with this lawsuit. Thanks. Mr. Mostrom, why do you believe she owes you $1,000?
As I put in the addendum, back on February 9th, I issued the $1,000 cash advance under, again, multiple pretenses that we both talked about in person and text, and email, and every sort of communication, that she would be working those funds off as time proceeded. And I issued her the advance based on the understanding that it was going to help alleviate the stress that she was having with her parents at the time, as they were constantly on her for not paying back her monthly student loan bills. Cecilia was stressed out. I was mentally, emotionally affected. She was in tears multiple days about it. I was just trying to help in that retrospect. And the company needed the help too, as time progressed too, that I needed more hours put in on her end as well, because I couldn't do it all myself. And again, she multiple times agrees throughout that time period that she would be doing that. And then of course she never did.
Before we go farther, I guess I need to take a minute and talk about what small claims court is about.
Mhm.
This is a separate division of the 3B district court. The
Mhm.
rules are much more relaxed in small claims court.
Mhm.
Neither part, sir, we're in a court proceeding. I'm gonna ask you to put the Red Bull down. You were drinking before, but we hadn't started yet. So pretend we're in a court hearing.
Mhm.
People don't smoke or eat or drink while we're in the hearing. Neither party's allowed to have an attorney. There's no formal record being made of the proceedings, and any decision here is final. Either party has the right to remove the matter from the small claims division to the general division of the court. You have to tell me that before we begin. Mr. Mostrom, you agree with that?
I do agree. Yep.
And Ms. Stalzer, you agree as well?
Yes, Your Honor.
All right. Was she an employee of the company at that time?
Yes, she was.
What was her position?
We had her put in as administrative assistant. Her title on her email was office manager on that retrospect as well.
Was she salaried or hourly?
Hourly, and her hourly pay was $18 an hour. Which it was noted within the pay stub. That it was an advance, and it would total of 55.55 hours of work at that rate of $18 an hour to equal that $1,000.
That's in the pleadings. Was that supposed to be 55.55 hours of work as overtime each week, or she just wouldn't get paid for a week?
No, in general, just total amount of hours in general worked.
Well, how was that to be tracked?
Well, we track based on what she was doing. If she was working, then it all goes into my workforce, which is in QuickBooks via login.
All right, well, so she worked no time after this? She gets no
She
return?
worked 0 hours after this advance was given.
All right, I didn't understand that.
Mhm. Shortly thereafter, the next weekend, there was a issue that she had with her family in her hometown. And then she did not come back after that point to do any sort of work related activities whatsoever.
I'm not telling you that anything you shouldn't know. This is fraught with danger.
Yeah.
You don't hire your girlfriend for your company, give her an advance and try to launder it through the company. And then when the deal goes bad, then you want your money back. That's very poor business practice. But she says this wasn't an advance, it was a gift. Ms. Stalzer, what's your position?
Yes, Your Honor. He tried on multiple counts saying that it was an advance pay, and I have text messages showing that I said no, and it would be held over my head, and I would send him a check, and he said no, it is for my loans and help with stress. And he kept saying no, thank you, that he would not take the check that I tried telling him I would give back. And he said he appreciates the offer though. This sounds like it's more of a relationship kind of thing rather than him just wanting the money. There was a domestic violence on him, and that was proceeding with the PPO that I currently have on him. I had multiple accounts where I tried to get him to leave me alone, and once the PPO was in place, that's when he proceeded with this court.
These are called small claims divorces by the district judges. Nobody likes these. Their relationship ends and it ends up in a small claims lawsuit where one party's trying to get back at the other one. All right, I was reviewing the texts, and as I said, one, they're hard to read, and two, it's hard to tell who's saying what. Do you have a specific date that you're, and the guys, you're really hard to read. Ty, going to send you a check because I don't want any of that held over my head anymore. Stop. No, it was for your loans to help with the stress. So the lighter colored is you, correct? Going to send you a check because I don't want any of that held over my head. Is that you?
Yes, Your Honor, and that was on 2/26 of 24.
All right. He says, stop. No, it was for your loans to help with the stress. That's him. Mr. Mostrom?
That is correct, on that.
All right. I wasn't asking you, I was asking her. So then you say parents are helping. No, thank you. That's him. As I said, I know you can work it off with helping me with work anyways. Was just a loan, quote unquote, to help initially, because there we were gone giving you crap every day and that stress on you. Appreciate the offer though. Mike, I don't want it constantly on my mind. And I can't read his response.
Your Honor, his next is, it's okay. Literally was trying to help with exactly what I said, and I knew you would work it off anyways, because I definitely need your help. And then I'm sorry for bringing it up yesterday. That's on me and won't ever happen again. I promise that. And then I proceeded with, okay, I asked why you'd like to not do it in the first place, and he said that he understands. And then I proceeded with, because I knew it would be an issue at some point. And then he said, I get it, it's all good.
What does that mean?
If you go a step farther, it then says, maybe you can drive me some places soon for work or get everything organized with office stuff like I need, or work on some dates. Is that fair? And she says, okay.
Well, that gives you a handle on her. She offers to pay the $1,000 back to just get it over with. So, and you keep calling it a loan, although it wasn't a loan she asked for. She didn't say, hey, will you lend me $1,000? You gave her $1,000 to help with stress. She offered to pay it back. And you said, no, you can work it off, which means you still got control over the situation. She just wants to pay it back and be done with it. And you deny the domestic violence, and I don't think there was a domestic violence charge, but there was enough that a judge in Ingham County issued a personal protection order. So after the personal protection order was issued, you filed this small claims for $1,000.
Actually, that was opposite. I spoke to her mother about filing the small claim stuff, and then her mother said immediately after in one of the text messages, that's when they filed the PPO.
Is that true, Ms. Stalzer?
Your Honor, the PPO was signed on 4/12 and it was served on 4/19. And he tried saying that I owed, and it was a formal notice on April 16th that I owed him this $1,000.
This was filed on April 29th. So the PPO preceded the small claims case. All right. Ms. Stalzer, anything else you want me to know?
Your Honor, other than that he continued to contact me and work things out relationship wise all the way up until basically March. I have messages over actually it was April 12th. This is his last text to me, and it was just like a picture, and it was a picture, and he just commented like a picture was taken over a year ago today. So it's just very confusing. And then also he invited me to go to Florida with him for work, and that I could just tag along. And this was also all after they tried taking me or threatening me to court.
All right, Mr. Mostrom, you're the plaintiff. I'll give you the last word. Anything?
Yeah, as I mentioned, there were 6, 7, 8 different times where she has basically understood that it was an advance, it was a loan to her that would be paid back. The reason why I did not accept it back at that February timeframe was strictly because she didn't have the funds to do it. The stress that she was having with her family was affecting her very, very much so. At the end of the day, yes, I'm a business owner. She was an employee of mine. The reason why she was an employee of mine is because she had 2 shoulder surgeries within a year and physically could not do other jobs. She didn't have time to even go and do an orientation or anything because she was in multiple surgeries. So I hired her as basically an option so she would have funds, which she did great work for months. Did a great job and helped me out quite a bit. It was just all of a sudden towards this end time where she decided to step away, and as you saw in multiple messages throughout, attacked me verbally quite a bit as far as how it didn't matter what I said or did. She was never going to pay me back, and I didn't deserve it at the end of the day.
All right. This is a end of relationship thing. And this is a power and control and manipulation by loaning her $1,000. Stop that.
I said sorry.
Which gave you some power and control over her. She offered to pay it back. You declined, and I'm not going to be used by the court to manipulate her any further. You get 0. I find no cause for the plaintiff. Defendant offered to repay the money. The plaintiff declined for reasons that he would still have contact with her. She filed a personal protection order, and after the personal protection order was filed, he filed this action to collect on this nebulous, poorly thought out, quote unquote, loan. I'm not going to be a part of it. You get 0. Ms. Stalzer, you're free to go on about your business. Mr. Mostrom, the PPO is still in effect. Maybe you can both move on from this, but I'm not going to be used to manipulate her any further.
Thank you, Your Honor.
Stalzer, you're free to go.
Thank you.
All right, that finishes our day. We'll be back tomorrow with arraignments, pre-exam conferences, prelims, and whatever else comes up. I understand I've got some more emergency here. Ever seen one of these? I used to do this.
Yeah. Those used to be in the file when I do pre-trials or as a prosecutor.
This is a 2010 case. And it's the driving record. You know, we don't have these like this anymore, but if somebody had a really bad driving record, it looked like this. And this one
Those
was-
were nice, because you can at least follow along.
Yes. Yes. All right, we'll let this run here for just a moment. We've got arraignments, pre-trials, and pre-exam conferences this morning. Hopefully they've got enough prosecutors to help. I had a case yesterday, a Three Rivers case they set for arraignment on Monday. And I don't know why, but he ended up pleading guilty, and so I didn't need assistance, but so I did DWLS. All right, well, let's get situated here. Okay, we are about to start. We do have a busy day. It's another beautiful day in Michigan. People are sweltering all over the place. It's been quite mild here. And we're waiting for some customers. Good morning to everyone. We have one more work day tomorrow, and then we'll be off Thursday and Friday like many people. The weather's supposed to be good for the 4th of July, so we're hopeful about that. We do have a lot of pre-exam conferences today also. Tim, do you have some of those?
No, sir.
You don't have any?
No.
Must be living right. Yes, congratulations to Grandpa Tyler. Zach, good luck in your first week of law school. Summer school's brutal. They cram a lot into a short period of time. Law school is a lot like doing 8th grade over and over and over again, at least the first year of it. There's nothing good about it. Just have to survive it. So good luck to you, sir. You don't have time to watch this if you're going to law school in your first week. So thank you for saying good morning. All right, I'm going to shut this off. We're all still thinking about Melissa Halleck. Every day you just keep going, but every time her name shows up on a pleading or you see her in a picture, it gives you a twinge. Have we got situated on what the bar was doing? You mentioned that, but
Yes, sir.
I guess I better get the details and share it somehow. I was gone when you had the meeting. Who's managing it? United Way?
We're doing something different over at Judge Commons.
I knew that, but I'm talking about a fund for the girls.
I don't think the bar decided to do.
All right, they haven't figured that one out. I know we're doing some memorial stuff for her. I'm gonna name a conference room on her behalf, and I think a bench and some other things at the probate court. Well, it is 8:15. We have not one customer. I'm the only court operating on this floor. Judge Tomlinson is not here, but he's not running his court. Judge Stutzman is here today. I understand he's gone tomorrow, so I'm the only person in the building, only judge in the building tomorrow. That's all right. So I'm not sure what's up with the bailiffs, but I'm sure they'll tell me something. We have a lot of pre-trials this morning also, which are always kind of problematic when they're at the same time as you got several Quincy, Washington cases, and some of Sinquest furlough is ordinances, some is statute. I haven't turned anything on because there isn't. I'm just recording time.
I saw you talking and that.
And yeah, you do have several pre-trials. I expected Vivian was gonna join us. I haven't seen her, and this guy from 2010 was supposed to come in by Zoom.
If they added an arraignment for a new Dusty Hicks charge of 1 o'clock this afternoon.
Don't worry about that.
Do you want me to just give you the reports?
Yes.
So you can have them?
Well, you know, he's somewhat unstable. I was hopeful to maybe resolve everything. And when I set this stuff, I told you, I didn't want to make you guys come over for it. I think you had given some sort of an offer.
Yeah.
But yeah, there's a new one also. I don't have the afternoon files with me. He's the only prelim I've got, except for this afternoon. And there's the whole issue that he believes that he owns a piece of real estate. I don't even exactly understand it.
Right.
Like a piece of sidewalk or something. But so I'm not sure where we're headed with that.
But it looks like the disorderly is the same type of.
Yes.
conduct.
Good morning, Mr. Stickley.
Good morning. I'd love to help you guys.
Mr. George and I are having a wonderful time here.
I'm looking for customers outside. We have none.
Not one person is here?
Nobody.
Boy,
We're
that's
trying to strum
a
some-
new low.
We're trying to strum some up.
Well, here's somebody. Good morning, sir.
Good morning.
You're Mr. Parrish?
Yes.
Have a seat, sir. I haven't seen you in very many years.
Yeah, I was trying to keep it that way.
We're gonna wait a minute, see if any other customers come rolling in.
There might be more people sitting on the bench out here.
Well, we've got both.
Check to see if any are-
All right.
I think there are some.
Well, if Miss Furlow doesn't show up, I'm gonna issue bench warrant for her arrest. Well, it is a beautiful day. I guess nobody felt like coming to court.
Yeah, I didn't, but.
But you did anyway.
I don't think anybody ever feels like it.
No, sometimes we don't feel like it.
Not like to have that job.
Oh, it's a privilege to have this job, but some days are better than others.
Sure, sometimes it is. Have to make some hard choices sometimes, I'm sure.
Yes, that's the nature of the job. Well, you're here for a pre-exam conference, not an arraignment.
Yeah, I already spoke with my attorney.
Very good.
Might want to talk to me.
Okay, well, just have a seat. When he comes in, we'll address it. We had a gentleman from 2010 who has an old no ops that's jamming him up. And we scheduled an arraignment for this morning via Zoom. And he's not here. All right, the record is not on. The live feed is on. Once again, the world's most boringest live stream. We'll wait and see whether we can generate any business before the felony cases start. Mr. George has gone out to work on some pre-trials for the city of Three Rivers. I don't remember a day when no one showed up. Good morning, Luke. Tuesdays are very often our busiest, not very often, usually our busiest day. We have misdemeanor arraignments with Three Rivers and some other villages and state statute cases. We then have some pre-trials for those entities, and then we have felony pre-exam conferences. And sometimes I have both, and sometimes I have just one or the other. Today I have both, and we don't have any customers.
Couple more.
Well, I'm waiting for a bailiff to come in and give me some sort of an update. Then we'll go on the record and address each case. We'll get busy when the attorneys come in on the felony cases. All right, we're on the record. Yes, we are. This is Tuesday, July 2nd. We are doing or attempting to do arraignments except no one who was supposed to be here for arraignment has appeared. First of these is Eduardo Cruz Agapito. File number is 241101. It's an ordinance case from Three Rivers, no valid operator's license and no proof of insurance. Mr. Agapito has several other matters. No proof of insurance and registration plate, which I think is the same thing. This is his first failure to appear. He lives in Constantine at the trailer park. Any luck with the pretrials?
We just had one, Your Honor, and it's reset.
Did Mr. Washington show up?
That was our pre-trial.
Okay. Eduardo Agapito has a failed to appear. Trying to order show cause first. I don't know what's going on. Look at the Supreme Court ruling about immunity. Made everybody feel they didn't have to show up. Sanquez Furlow has bunches of cases. Shows $1,545 in unpaid fines and costs. She has several other cases pending. And she's failed to appear several times on this case, which is no insurance, file number 24911SM. Driving with, and that was from May 23rd. Driving suspended second offense, also from May 23rd. And she has no valid operator's license from June 1st. And no proof of insurance from June 1st. So she's got cases pending. She got stopped on May 23rd, and then she got stopped again on June 1st, and she's failed to appear for most of these hearings. So I've done show causes, and this is the show cause to show cause why she shouldn't be found in contempt. She hasn't gone anywhere, but she just doesn't show up. I don't have a phone number. I already did a show cause twice, hoping she would appear. She did call once. She owes $1,500 plus and fines and costs. She has multiple cases pending. She keeps driving without any insurance. So I'm gonna do bench warrants in each case. Bond is $500 cash or surety per file. That's 24911 SM 24912 ST 24964 OT and the civil infraction. She also has pending. Here's a bailiff. Good morning. Mr. Agapito is here. All right, have a seat, sir. So if anyone knows Miss Furlow, she needs to, civil infraction. She also has pending. Here's a bailiff. Good morning. Mr. Agapito is here. All right, have a seat, sir. So if anyone knows Miss Furlow, she needs to, she got arrested on a bench warrant. I let her out, and then she promptly failed to appear on other stuff, and she keeps driving. So she needs to get in here. Mr. Agapito, do you need an interpreter? Okay, well, we'll hope for the best. We don't have an interpreter here. He's late to his own party. Why don't you both come up and have a seat? We're happy to have any customer, but we have a lot of no-shows this morning. What's your name, ma'am?
Shayna
Shayna, what's your last name?
Ortiz.
Can you speak both Spanish and English?
I do.
Normally, we would have a certified interpreter here and get one of our staff. But we'll make do with this. So Ms. Ortiz, I'm going to ask you if you please raise your right hand. You swear or affirm to the best of your ability you will interpret these matters from Spanish into English and English into Spanish.
I do.
All right, which is your first language, English or Spanish?
English.
And how did you learn Spanish?
School
Where'd you go to school?
in Goshen, Indiana.
Well, we do a notoriously bad job in America of teaching foreign languages in school. All the foreign kids, the German kids, the Dutch kids, yes. We're gonna limp through with this. All right, thanks, bye. All right. Are you? And I don't know why, oh, he has an advisor rights. Good morning. You're on the attorney's side.
Oh, I'm sorry.
You have to pay $5 if you want to sit on that side.
Okay, sorry.
For you, $4. I'll give you a discount.
I appreciate it.
Anyway, are you Eduardo Agapito?
¿Tú eres Eduardo Agapito?
Sí.
Yes.
You got a ticket in Three Rivers.
Yes.
For driving without a valid operator's license.
Por manejar sin licencia.
That is our most common ticket.
Eso es el más común.
Yeah. Sí. Ms. Ortiz, I'm not sure I actually swore you in. Ms. Roberts came in and I got sidetracked. So did I actually ask you to swear?
You did
it. In Michigan, that is a misdemeanor.
En Michigan, el cargo es misdemeanor.
Delito menor.
Say that one more time.
Delito menor.
It's,
That's
oh,
a
it's,
misdemeanor.
oh, yeah. Es un delito.
All right. It is punishable by up to 90 days in jail.
Puedes resultar en un castigo de 90 días en el cárcel.
And a fine of up to $100.
Y un cargo de, how much was the money amount?
$100.
$100.
It also carries 2 points on your driver's license.
Igual vas a tener 2 puntos en tu licencia.
You also got a ticket for not having any proof of insurance.
Igual te dieron un ticket por no tener seguranza.
And that is punishable by a fine of $150.
Y eso es un castigo de $150.
Mr. Timothy George, the Three Rivers City Attorney, is here.
He's who?
Timothy George, the Three Rivers City Attorney.
Él es Timothy George, el abogado de el ciudad.
Mr. George, would you dismiss the no insurance?
Yes, Your Honor.
Dice, le
This-
pregunto que si
The city attorney would dismiss the civil infraction
el abogado te va a quitar el cargo de civil
if you plead to the charge of driving without a valid license.
si dices que eres culpable por manejar sin licencia.
Do you understand?
¿Entiendes? Yes.
You have to speak your answer.
Tienes que hablar las respuestas. Yes.
All right. Are you pleading guilty to driving without a license in Three Rivers on June 15th?
¿Vas a decir que eres culpable para el cargo que te dieron ese día? Yes.
Where were you going?
¿A dónde ibas?
Walmart.
Walmart.
Where were you coming from?
¿De dónde ibas?
Constantine.
From Constantine.
And you live in the trailer park in Constantine?
Yes.
Do you have a valid license?
¿Tienes licencia que es válida? He has in a different country.
Or what country?
¿En qué? En Mexico.
Which state?
¿Qué estado? Tamaulipas.
I don't know that state.
Nuevo León, Monterrey.
Monterrey.
Okay. Is that license still valid?
Is it todavía es válido?
México.
Yes.
How long have you been here in Michigan?
¿Cuánto tiempo llevas aquí en Michigan?
It's coming 7 de septiembre.
September 7th he got
Last
here
year.
of last year.
How long in the United States?
¿Cuánto tienes en los Estados Unidos?
Tenía
O
poco
en
tiempo.
como
7
cuánto?
años. 7.
He said about 6 years.
All right. Once you move here, you need to get a license here.
Cuando vienes a quedarte en los Estados Unidos, tienes que sacar la licencia de
And the
aquí.
problem is you can't get a license unless you have lawful residency status.
Y el problema es si no tienes tu permiso de vivir aquí, no puedes sacarla.
Sí, y apenas compré.
¿Cómo?
Le digo que nunca había manejado, apenas compré el carro.
And he said that this was his first time buying a car here.
Well, I can't fix this, but you can't drive.
Él no puede arreglar eso, pero tú no puedes manejar.
So if you drive some more, you'll get pulled over again.
Si manejas más, sigues manejando, te van a parar otra vez.
Sí, sí.
He understands.
Did anybody threaten you to get you to plead to this charge?
¿Alguien te dijo que te iban a hacer algo para que fueras culpable de este cargo?
Como que se me iban a ayudar.
No. Si alguien te dijera que te iban a hacer algo mal, no.
Anybody promise you anything?
¿Te prometieron algo? No.
Can I get that advisor rights in it? I'm going to fine you $100
Te va a cobrar $100
plus the state costs of $125.
más lo que cobra el Estado son 125.
The charge of no proof of insurance is dismissed.
El cargo de sin seguranza es ya no está.
That saves you $150.
Te estás guardando $150.
So the total amount that you owe here is $225.
El total que vas a deber aquí son $225.
Do you have that with you or do you need time to pay it?
¿Lo tienes contigo o tienes tiempo para ¿O tienes tiempo para pagarla? He has it.
All right. There's also another ticket of no registration, and I'm not clear what that is.
Dice que también hay otro ticket de que sin la registración y no entiende por qué o
Bueno, o sea que yo no sé nada de eso, más me lo vendieron, pero dijeron que estaba bien.
I'm not sure if that's a different date.
he said it's from the same day.
All right.
Um,
Are you willing to dismiss that also?
También de pronto si la va, está bien si lo dejan ir ese cargo.
All right, I'm gonna ask you to go out to the counter and pay this fine. There is a lady there who speaks Spanish and can help you with this.
Hay una muchacha afuera que te va a ayudar para que pagues el dinero y ella también habla español.
Ms. Ortiz, thank you for your help. That probably
welcome.
wasn't perfect, but
You're
it
welcome.
was adequate for what it was.
Yes,
Okay, thank you.
thank you.
All right, we were going through the people that didn't show up. In that vein, we have Julian Ellsworth Marquez of Oak Plains, Three Rivers. And he has failed to appear. Sir, you're on the attorney's side. There used to be a little gate there. Julian Marquez has many unpaid fines, $510. It seems he just failed to appear in another case. Let's see what we can do here.
Your call has been forwarded to an automated voice messaging system. 2 9 8 5 8 5 3 8 5 is not available. At the tone, please record your message. When you've finished recording, you may hang up or press 1 for more options.
Good morning. This is Judge Middleton calling from the bench for Julian Ellsworth Marquez. He failed to appear for arraignment this morning on a charge of disorderly person. You also have $510 worth of other unpaid fines, including an earlier disorderly person. So I'm about to issue a bench warrant for your arrest with a $500 cash or surety bond. So you need to get in here and deal with that or be subject to being arrested. Have a nice day. There's a previous disorderly from just a while ago. Bench warrant. Bond, $500. Cash or surety. Good morning, Luke.
Morning, Judge.
Mr. George, I hope to have you out of here in just a minute. Anthony Rhodes. Anthony Keyshawn Rhodes. There are several Anthony Rhodeses. This is first failed to appear. He is local 241103. No phone number. If anybody knows Anthony Keyshawn Rhodes, he needs to get in here. All right. We'll do another show cause in that case. Good morning. Ross Eugene Sullivan. Driving system, yes. Oh, okay, Mr. Sullivan, I didn't know you were here. Come up to the podium if you would. This is an ordinance case. Good morning. Are you Ross Eugene Sullivan?
Yes, sir.
Mr. Sullivan, you're late, but at least you're here, so we can deal with this. Did they give you an advice of rights?
Yes, sir.
All right, very good. You got charged alleging that on June 15th, you were driving with a suspended license. This is a Three Rivers ordinance case. And they also charged you with no proof of insurance. Let's take a look at this. They say it was at 21:50, which is about 10 o'clock at night on June 15th in White Pigeon. So this isn't your case, Mr. George. Let's see if I have any offer. Laura, do I have any offer from White Pigeon on this case that I missed? Last time I sent him an email and he had already sent me something. All right, thanks. Give me just a moment, Mr. Sullivan. Morning, Mr. Robert.
Morning.
We're seeing, in fact, almost everybody this morning had a no proof of insurance attached to their case. People are struggling to pay all their bills and they're driving around with no insurance. Every time I get a ticket for no proof of insurance, I realize it's actually a break that they got on no insurance. Having no insurance on your vehicle is a misdemeanor punishable by up to a year in jail and a fine of up to $500, not less than $200. And very often the officers will just write a ticket for the civil infraction of no proof of insurance. And no proof of insurance means you didn't have the slip in the car, but you actually had insurance. And almost everybody this morning had no proof of insurance. Also, if you don't have a valid license, it's hard to get insurance because you aren't supposed to be driving in the first place. So what I've done, Mr. Sullivan, is I've sent an email to the city attorney for White Pigeon. He usually sends me a email a day or so before the hearing with any plea offers from the Village of White Pigeon. So I haven't heard from him yet. So if you'd have a seat for a minute, we'll see if he responds. All right, that is the last of my misdemeanor arraignments. We also set a special Zoom arraignment for Michael Lee Williams. And Mr. Stickley, I won't do this again, but this is a file from 2010. And it has one of those.
Oh, boy.
Mr. O'Bear used to see these.
CVS receipt.
They aren't paper like that anymore, but I used to take great delight in rolling them out in front of the bench. That's what this is. But it's old and he's wants to take care of it. So we set a Zoom arraignment for him and he didn't show up. So I'll set that aside. Regarding our last gentleman. Great. Here's some more stuff from Judge Tomlinson. Mr. George, I guess that's all I have for you.
Yes, sir. We were 2 for 4 on the free trials, so nothing additional for the free trials.
Okay, 2 people before showed up and neither was resolved. Did Anthony Grant show up?
No, sir.
Did anybody inform you of any polys today, or you don't know yet?
I have not, I didn't see any apparent ones when I looked at the jail roster. When I left last night, it was a 114 when I got here this morning. Oh, all right. Do we have any polycoms?
Sorry, what?
Do we have any polycoms?
There's also.
Okay, you heard it right from the source.
Awesome. Thank you. Yeah.
All right, Mr. Grant called and he's been reset. He's not the kind of guy that doesn't show up. All right, I'm gonna stop the records for a moment. We're gonna switch from misdemeanor to felonies. We have Mr. Joshua Robert, the Chief Assistant Prosecutor, with us this morning and a number of defense attorneys. Josh, do we want to take a minute and see where we are? Good morning. Things always seem to go smoothly when you come. So don't screw
It's
this
my
up.
years of experience.
Don't screw this up. Actually, they go fine when Mr. Marvin comes too. Luke seems to be the duty attorney for this week, so let's set his cases aside for a minute. Let's talk about Mr. James Roberts. Mr. D'Agostino is here.
He's still in talking to Mr. Marvin,
Okay,
but we have the attorneys for Robert Willis here, which should be a quick one.
all right. Let's talk about Robert Matthew Willis.
Good morning, Your Honor.
Good morning.
Kristen Mertens Carlin on behalf of Mr. Willis, Your Honor.
Thank you. Please have a seat. We've segued into our pre-exam conferences, so the live feed says misdemeanors. Did Mr. Willis get fingerprinted?
He did. He
Okay.
was in the process when I arrived.
I'm not sure how somebody gets arrested for this and doesn't get fingerprinted at the jail, but we're still working on that. Anyway, this is a charge of operating while intoxicated, 3rd offense, driving with a suspended license and impeding traffic. Seems like in light of everything else, impeding traffic seems to be a bit of overkill, but let's talk about this. A ticket was issued on June 6th at Parkville and Mankey Road. I drive past there every night on my way home. This was about 11:28 in the evening. Because of previous convictions, the matter was converted into a felony charge. The defendant was charged with operating while intoxicated as a 3rd offense. that is a felony punishable by up to 5 years in prison used to carry a mandatory minimum 1 year in jail. If you got convicted of this, you had to do at least a year in jail, 365 days. Doesn't do that anymore, but it does carry a 6 points and a suspension of your license. Driving suspended is a misdemeanor punishable by up to 93 days in jail and fine of up to $500. And impeding traffic is a civil infraction punishable by $105. I've got this on my radar. I'm the sobriety court judge. Mr. Robert, what's the status here?
So the offer is for an OWI second. I believe there's going to be a request for an adjournment today. We don't have all of the digital evidence that the defense would like to review for doing that. We also discussed sobriety court and what he'd need to do to make sure he's reviewed for that if he doesn't have a plea.
Oops. Well, let's talk about that for a minute. Operating while intoxicated, second offense is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. In order to get into sobriety court, you have to have at least 2 drinking driving offenses. That isn't something to aspire to. Let's say, hey, let's go get another drunk driving so we can get into sobriety court. But under our guidelines and the state guidelines, you have to have at least 2. We've had people that have had as many as 9 prior offenses. Your driver's license is going to be revoked, meaning that at least 5 years before you can get your driver's license back. If you go into a certified sobriety court treatment program, which ours is, I can help you get a driver's license with an interlock device to drive back and forth to work. I could also defer a large portion of jail, like 180 days worth, if you participate in the sobriety court program. And you're going to need, if you're interested in being in the program, you're going to need to go through a screening process and do some things to become eligible. And I think, let me give that to the attorney. That's something to discuss. So at this point, we're still waiting for additional discovery.
Correct.
What are you to buy body cam stuff?
Yeah.
Was there a blood alcohol here?
We're waiting on the final blood draw.
So we don't have that either.
Correct.
So that's certainly important. And do we have a PBT or anything?
There was a PBT error. It was very high.
It was a 0.213.
Thank you. Yep.
I'm aware of your case because I look out for these for people I think would be appropriate to come into sobriety court. We like to get them in if they're interested sooner rather than later. So I provided the information regarding the referral to your attorney. How long do we want to continue this?
Doesn't matter to me.
Do you know how long realistically for the digital evidence?
I mean, our staff will request it again today. So I don't know if 2 weeks keeps it on your schedule or if you want longer.
It would, except I would be not here. As I said, I usually want to do this sooner rather than later. I'll be here on July 23rd. I come in the middle of my vacation every year to do sobriety court and landlord tenant. So I'll set this, continue to 9 a.m. July 23rd for PEC. And if necessary, a prelim would be July 30th. At 1. That should be enough time to get the lab report back and get the other stuff. Also, for you, if you want to get more information on our sobriety court, call that number. And Autumn can advise you on what you need to do on behalf of your client.
And Your Honor, I don't know if it will speed anything up, but my client has already been in touch with Pivotal and spoken to 2 people there.
I saw he had a Pivotal folder or something in his hand, so.
Yes.
What do you do, Mr. Willis?
I'm a material handler at Morgan Olson.
I think you told me that at the arraignment. When did you have your last drink?
The 6th.
All right, that was my guess. So you haven't had a drink since this incident?
No.
That's a good start. That's a weird place to be at 11:30 at night. So I'm more interested in hearing about where you were going, what you were doing. But we aren't there yet. At this point, you're still presumed to be innocent. They're gathering all the information. If you're interested in sobriety court, we can discuss that further. If you aren't, you're entitled to have a preliminary examination on this matter. Anyway, we'll adjourn this till July 23rd at 9 o'clock. And I'll put it on JCM calendar. We're the only one I have that day, but I will be here that morning and that afternoon. All right, Mr. Willis, you're good to go.
Thank you.
Thank you, Your Honor.
And you still can't drive, so don't drive anymore. So you got a driver with you today. All right, very good. All right. What else do we know?
I don't know if Ross has.
I do.
I guess.
Yeah. So the Miss Cheyenne Smith. The legal attorney, so that's what I asked for. Paul's substitute there. I'm surprised you when I told Judge.
Good morning, Mr. Truckee.
Morning, Your Honor.
You're here on Cheyenne Smith.
Yes, she's present. Mr. Gibson is
Why don't you have her
substituted
come
in.
forward? Good morning. Might have a seat. How do you say your name? Cheyenne, okay. All right, Mr. Truckee, I interrupted you. I'm sorry.
I had a conflict on this case. I received it from Mr. Knopfinger because he had a co-defendant. And I represent another person present in another pending matter. And so Mr. Gibson is substituted in. We've signed a substitution as filed, but he was unable to be here today. So I'm just here to request this be reset to next Tuesday for PEC and the following Tuesday for preliminary.
All right. Who's the co-defendant?
Mine,
Who's Luke's co-defendant?
Rebecca Simons.
Okay. Is that set for next week?
I think that's set for today. This morning, Judge.
All right, well, Miss Smith, you're here. That's a good thing. Are you still living at 100 West? You have a different address?
I did update that with community corrections as they told me to when I got.
Okay, so you're under pretrial services with Melissa?
Whoever they had on my paperwork that I was supposed to call, I called them.
All right.
And then did update the new address.
All right, we're gonna adjourn the pre-exam to July 9 at 8:30. And prelim if needed to July 16, 24 at 1. Because I don't have your address, I'm just gonna give you a notice right here. I apologize, my handwriting is bad, it's getting worse. What do you do, Miss Smith?
I'm unemployed. Uh,
What kind of work have you done?
Nursing home care, restaurant, like,
Okay.
waitressing, human services, just all variety really.
All right. You'll get probably another notice, but I want to make sure that you know. And
I did update your honor on my address with fingerprinting.
okay, very good. Anyway, I will see you next Tuesday morning at 8:30.
Okay.
Thank you, Your Honor.
Thank you. Is that all you had today, Ross?
Yes.
Is anything going on in Three Rivers in light of Judge Tomlinson's absence, or
This
it's a
week's
slow week?
pretty quiet over there.
Oh, good. He's not absent, he's just taking some time off. He was at the judge conference last week. and- Thank you. All right,
Have a
Ross,
happy
thank
Fourth,
you.
Judge.
Thanks, Ross.
Okay, that brings us, Mr. Felt and Mr. D'Agostino are out and about, but let's talk to Mr. Knopfinger. He's got the bulk of the cases this morning. Right now, we're just gonna sort of do an overview of what we're doing here. So let's just start right at the top. Alonzo Ballantyne carrying concealed weapon.
He's present, Judge. He's not in the courtroom. He's in the lobby. He's fingerprinted. Case will be resolved with the plea.
All right. I haven't seen Mr. Ballantyne in many years. All right, Jordan Dieter.
He's incarcerated, Judge. Case will be resolved with the misdemeanor.
All right, Wilbur Holden.
He's present, Judge. He's going to require some hearing accommodations, but that case will be resolved.
All right, Patricia Odell.
She's in custody, Judge. We've worked out a plea agreement with the prosecutor.
Is this a sobriety court case?
Her convictions won't result in a license suspension, so.
Yeah, that one is way old, 2006.
Yeah, so because
What's
of
the
that,
plea offer to?
OWI second and attempted RNO. So we had that discussion, Judge, and
All right, we'll set her aside. Morgan Scott Parrish.
Judge, I want to dig into this one a little more. Spoken to the prosecutor, there is a 7-day waiver that's signed if I can tender to the court.
Mr. Parrish is another blast from the past. Why don't you come on up here and have a seat with your lawyer? He said he wasn't mad at me, but he just didn't want to come visit for about 10 years or so.
Right.
Good morning, sir. Are you Morgan Scott Parrish?
Yes, sir.
And you were here bright and early. We're going to adjourn this. You've agreed that we can adjourn it outside, the 7 days that are required for a pre-exam conference. What are we doing? Some additional discovery here?
Yes, Judge.
His client has something that he wants to view. It's not discovery from us.
All right.
Could be potentially, but to make that assessment, I'm not sure when the court would. Want to set the.
Well, how long do you need?
2 weeks.
All right, I'll continue this to 7/16/24 at 8:30 for pre-exam. And a prelim, if needed, would be 7/23/24 at 1. Mr. Parrish, are you still at Sewanee Trail?
Yes, sir.
I'm gonna give you a notice also. Courtroom B. Judge Patterson will be here that day. All right, Mr. Parrish. 2 weeks, see where we are at that point.
That possibly get this thing off my ankle?
No,
Pretty embarrassing.
well.
You know me.
I know you. I didn't set the bond, the magistrate did. But these are some serious charges that involve firearms, which you aren't supposed to be carrying. So we can discuss that further, but was there a misdemeanor offer? Or is this gonna be a circuit court case?
No, there's not a misdemeanor offer on this case.
Well, you can discuss that further, but right now you're on pretrial services and you're on an ankle monitor because of your past baggage and the nature of these charges. So see what we do in 2 weeks. Thank you. Then we have Rebecca Simons.
She's incarcerated, Judge. Case will be resolved this morning.
And then we have Nicole Wood.
That one's kind of up in the air at this point.
This Wood here,
She is, Judge.
she been printed yet?
Yes.
Okay, I'm gonna hold on to that one. All right, we're gonna take a short recess, then we're gonna come back in and take all these pleas one by one. We'll be back at about 20 after 9. And everybody take a break and we will start to work. We have to do our in custodies by lunchtime, but we'll start out with the people that are actually here. Then we'll deal with the people that are at the jail. All right, we'll be back in just a minute.
Judge, Mr. Holden will need hearing accommodation.
He's got it. Did that help, Mr. Holden?
Did this help you? Yes, sir.
Yeah, well, hold on to it. Yeah, have him keep it.
Very good, thank you. I didn't.
All right.
Hang on with
You need
this,
to relax.
and then when you come back in, and you hear.
Okay, Melissa, are you all set? And I'll bring Ms. Kirkpatrick back.
Yes, Your Honor.
Okay, thank you.
I'm not muted. Now I'm muted.
Ms. Kirkpatrick, you're going to be muted for just a few minutes, and as soon as you're automatically unmuted, we'll begin. Okay, very good. And we are here today on the record in the matter of the City of East Lansing versus Tiaja Kirkpatrick, case number 19-0620 OD. We're here today for a review and continuation of a probation violation sentencing that took place yesterday. May I have appearances please for the record?
Good morning, Your Honor. Robert Easterly on behalf of the city appearing via Zoom.
Morning, Melissa Vachon on behalf of Ms. Kirkpatrick, who appears separately by video.
And Ms. Kirkpatrick, we're here today. You're on Zoom today. First of all, can you confirm, are you able to hear and see me?
Yes, ma'am.
And we're here via Zoom. Ms. Vachon, you and I, we can discuss later whether if there's a need for resentencing, whether Ms. Kirkpatrick wishes to be present in person here, and which she has a right to do, and we'll address that at the appropriate time. Are you comfortable with that, Ms. Vachon?
Yes, Your Honor.
Okay, so we're here today because we had a probation violation sentencing yesterday, June 12th, at which time Mr. Easterly, Ms. Vachon, and Ms. Kirkpatrick appeared in person here at the 54B District Court. At that time, Ms. Kirkpatrick's probation was revoked and she was sentenced to 30 days in jail with 6 days credit. It was a full sentencing hearing. It was a fairly lengthy colloquy between the court and Ms. Kirkpatrick, who the court has worked with for some time on probation. There were some concerns by the court during that colloquy with Ms. Kirkpatrick, and then Mr. Easterly later on into the hearing alerted the court, notified the court that he was concerned that Ms. Kirkpatrick was under the influence of a controlled substance. And that was consistent with my concern as well, but was the first time that anyone had said anything expressly. And so we completed the probation violation sentencing. As I said, Ms. Kirkpatrick was sentenced, and just so the court is being perfectly upfront, there was a request for time served, which of course the court considers all arguments before it. And there was also a question of whether Ms. Kirkpatrick would be remanded or would be allowed to report to the jail. That was another consideration. But given the circumstances, the court did remand Ms. Kirkpatrick. At that time, the court officer administered a PBT, and Ms. Kirkpatrick had a 0.21 bodily alcohol content pursuant to that PBT. So we're here today because, as I talked with Mr. Easterly and Ms. Vachon off the record after that hearing, the court has serious concerns about whether what we did yesterday was appropriate and proper, and Ms. Kirkpatrick was even competent to have that hearing and participate in that hearing. So we're here today. I'd like to hear from the parties as to what they believe the court should do moving forward. Mr. Easterly.
Thank you, Judge. Just a little bit more context. Prior to the hearing, from down the hall, I could hear what was a very loud and public conversation in the hallway. It turned out to be between Ms. Kirkpatrick and her family. The content of that conversation was both inappropriate and in some ways irreverent to the court. And so, and I could hear it from the office that I was sitting in. By the time we made our way to the court, Ms. Kirkpatrick was inside of the courtroom. She spoke. She was calm. I saw her walk. She didn't appear intoxicated by alcohol. And the brief conversation that I had with her, she also sounded quite a bit more normal. It wasn't until we were on the record listening to her that those concerns arose again. And still, alcohol was not what was in front of mind based on her movement and the way that she spoke. But I'm glad that the court did take that step after sentencing. I don't know, obviously someone who's a 0.21, I would have concerns that they understood what was happening. But she also conducted herself pretty stably, even with a 0.21. But I, in terms of whether or not she knew and understood exactly what was happening yesterday, that would be hard to say. I think that the court should inquire as to that. And if we need to readdress or reconduct the sentencing, I'd be in support of that.
Mr. Easterly. Ms. Vachon.
Yes, Your Honor, I don't believe that sentencing needs to be reconducted. After speaking with Ms. Kirkpatrick, she does recall everything that happened and understood what was going on. She was coherent, and we did speak at length before the sentencing yesterday as well, and I have no concerns with that, Your Honor.
Okay. And I know that you have other attorneys from your office here today, and that is the consensus from the Ingham County Public Defender's Office.
Your Honor, my name is Keith Watson. I'm the Chief Public Defender, and good morning. I was lucky enough to be allowed to be into the private consultation just a moment ago with this client of our office. I would ask that Your Honor may enter into some colloquy with our client so that it can be clear from what it is she has to say, from her very words, her perspective, as has been expressed by Ms. Vachon, so there can be no misunderstanding that this client of ours feels that she was perfectly fine to make the decisions that she made, perfectly fine to understand exactly what was going on at the time that it was going on yesterday, this time that seems to now be in question due to 0.21 BAC. I was not given the impression, based on the information that I received, that there's any serious question about the interactions during the colloquy, for instance, between the court and our client, that there was some question about that until it was brought to the court's attention by Mr. Easterly at the end of the hearing. So perhaps I didn't get all of the information, but I would ask that Your Honor may inquire of our client as to her perspective concerning how she understood things as she expresses now, so that it's not just a lawyer expressing it on behalf of the client.
Thank you, Mr. Watson. Ms. Kirkpatrick, have you heard everything that the lawyers and I have been discussing?
Yes, ma'am.
So, Ms. Kirkpatrick, we were in court here at the 54B District Court yesterday, and at that time, you, according to the information I have before me now, were intoxicated, and we were here for an important hearing. It was a sentencing. Sentencings are always important. In your case, you received a jail sentence where the court imposed a term of incarceration that I consider to be very serious when I take away someone's liberty. And I did that while you were severely intoxicated. So I have several layers of concerns, but first of all, Ms. Kirkpatrick, do you remember and recall being here at court yesterday?
Yes, I remember, Your Honor.
Okay, and do you remember the conversation that you and I had when I asked you what you wanted me to know before I imposed sentence?
Yes.
And do you think that what you told me was impaired in any way by the fact that you were intoxicated?
No.
Would you tell me anything differently if I were to resentence you again?
Not really. Yesterday when, I got sentenced, I figured I was gonna be done with that. I was happy with the, even though I did have to go to jail, you know what I mean? Like, I was happy with the outcome of the sentence, just because I do have a child out here and I'm just trying to get back into the regular world. So, I don't believe that I was in any way. I understood everything.
Okay.
I wouldn't go for a resentencing, but, completely up to you, Your Honor. I felt like, we should just stick with the sentence that I have now and, just not, drink, or when I do get out, I would seek help.
Thank you, Ms. Kirkpatrick. Ms. Vachon or Mr. Watson, Mr. Cornish, anything else you'd like to inquire on the record?
No, Your Honor.
So Mr. Easterly, anything you would like the court to inquire of Ms. Kirkpatrick?
No, Judge.
So the court is, given Ms. Kirkpatrick's answers today, is satisfied that she, at a 0.21, which raises its own concerns, was actually functioning yesterday and does have a memory of the events and was able to participate and did have control over her responses to the court. And as she said today, she wouldn't have changed those responses and has nothing more to add. Nonetheless, this court is still concerned not just with Ms. Kirkpatrick, but with the court, the justice system, and the respect and the perception of the justice system. And I am not comfortable saying that a sentencing hearing where I imposed a jail sentence that I consider significant, where a participant was a 0.21, was good enough and was the way that the court is supposed to operate. I don't want to over exaggerate things, but I do feel that there was a level of, if not making a mockery of the proceeding, that proceeding certainly is not how court proceedings, serious court proceedings where people's rights are being determined, are supposed to be conducted. So I am going to order that we will resentence Ms. Kirkpatrick when she is clear and sober. And we will, Ms. Vachon, unless Ms. Kirkpatrick wishes to, we'll do that in person, as Ms. Kirkpatrick has the right to do. So we will get a next date.
So you're gonna sentence me to more time than what you just sentenced me to?
Ms. Kirkpatrick, that is not at all, I mean, first of all, inappropriate. You are not supposed to, you should address questions to your attorney.
Ms. Kirkpatrick, we can talk after the hearing.
But I'll just state for the record that this is, the court has not said that Ms. Kirkpatrick is being held in contempt, which would be a separate proceeding. Certainly could be appropriate under these circumstances, but that's not what I'm saying here. What I'm interested in is protecting and maintaining the decorum and the respect for court proceedings. And it's not about you, Ms. Kirkpatrick, it's a broader concern that the court has. So if Ms. Vachon, you can discuss that more with your client, but I've made myself clear there. So Monday, June 17th at 2 p.m. Mr. Easterly, Ms. Fashan,
Yes, Your Honor, that works for us.
thank you.
That works as well, Judge. 2 p.m.
2 p.m. and we will be here, the court, and we'll make sure that Ms. Kirkpatrick is transported, and we'll see everyone then. I thank you all for your patience here today, and thank you for your appearance. Good luck, Ms. Kirkpatrick, and we'll see you on June 17th.
Thank you, Judge.
Okay,